Are you out there working more hours than you're getting paid for? Are you not getting the proper pay for holidays, for overtime, for things like that? This stuff's happening all the time. And this week on Monday Morning Lawyer, we've got an expert who handles these claims for people all the time. And we're going to talk about it and answer some important questions to find out if you might deserve more pay than you're actually getting. What's going on, everybody? Happy Monday morning. This is your accident injury guy, Jobeth Bowers, coming to you from my Elkton office, where today we are not talking about auto accidents. I am about to introduce a guest to you. It has been a hot topic. I've gotten a couple of calls about it. I've seen a lot of stuff flying on the internet about it. We're going to talk about employment law and specifically a topic commonly known as wage theft. And I'm going to introduce my guest. I'm not going to waste any time here.
Jobeth, thank you very much. I'm having a little hard time hearing you, but I appreciate the opportunity to.
Is that any better?
Oh, wonderful! Thank you so much.
Good. I must have missed the call on my microphone there. So, Bruce, you've been doing employee, and I want to be very clear about this because a few weeks ago we did an episode that was geared toward people who run businesses and common scams that attack them. So I don't want to get this confused. We are talking to employees today.
Sure.
You've been representing employees in various sorts of employment type of disputes for quite some time now here in Maryland and DC, right?
Yes, I'm licensed in both jurisdictions, and I've been doing employment law heavily or substantially for about half my career. As the gray hair up top may suggest, I've been practicing for almost 30 years, as it'll be in December. And for about 15 of those years, I've been active in various parts of the representation of workers in a substantial way, whether it's wage and hour, unpaid promised wages, other wage issues that can come up, as well as things like sexual harassment, discrimination on the job, wrongful terminations. We usually don't like to use the word wrongful termination because it is a junk drawer of different types of wrongful terminations and the like. Now, I don't only represent workers, but I overwhelmingly represent workers. About 90% of my practice, maybe 95%, is representing the recipient of the paycheck, not the one signing the paycheck.
Gotcha. Okay. Now, first of all, before we dig into this, a point of order. You mentioned that the graying hair might show how long you've been in this profession, but I'm convinced that that's like 2-3 years in, you start showing the signs no matter what, but let's be real.
Point taken.
So the main thing I want to talk to you about, I think, is a real hot button issue because there's over the past handful of years, so much has changed in the employee-employer relationship. We've got more people working from home. We've got more people, I'm convinced, that are working gig-type jobs, things that are kind of like, ride share and other sort of turn it on, turn it off sort of things. And things have gotten a whole lot more complicated. But I think that one of the things that I'm seeing a lot of complaints of are, and a lot of these things come up because I've been referring people to talk to you for decades now. At least it feels like that. And again, that may be going back to the whole 2-3 years to get this, silvering going on here. But this concept of wage theft, people not getting paid for the hours that they're working. And I've seen this, and again, I just touch them and say, hey, you need to talk to Bruce. But where does this commonly show up? What are things that people might not even realize that they're getting shorted here? What should they be looking for? Where does it commonly happen?
Well, a little perspective. Wage theft is nothing new. There's wage theft in the book of Genesis, in the stories of the early patriarchs in that book. There's an issue of wage theft, someone being promised a certain amount of, I'm not a biblical scholar, but it's in Genesis, it's in Leviticus, it's in the Christian scriptures, it's in the Islamic scriptures, as I have learned from Muslim friends. condemnation and moral condemnation of the abuse of trust by bad employers. Most employers and most employees are average. A few employers and a few employees are great, and a few employers and a few employees are terrible. And I sue the ones that are average and down, because the great ones obey the law. The average ones mostly obey the law, but maybe commit small violations the same way that, I don't always do the speed limit on the Baltimore Beltway. I've been known to do 58 and the 55. Not that big a deal. The police mostly.
Yeah.
And then, the ones who get caught doing 100 in the on the Beltway, that's my preferred defendant, especially if they are well funded and can reasonably sustain a judgment and pay it if I go after them. But wage theft can basically happen anywhere where there's an employer and an employee, and an employer being able to take advantage of the breach of trust of getting the work before getting the pay out the door in the proper amount. The analogy that I often use for wage theft is this. And when you imagine, I don't want to pick one store over another, but a Royal Farms, a Highs, a 7-Eleven, any convenience store, a Wawa, Sheetz, pick your poison. If you go into a Sheetz or if you go into a 7-Eleven and you bogart $100 worth of Crackle bars or $100 out of the cash register as a customer, you can realistically expect that if there's an officer who sees it happen, if the officer's there, you're going to do a ride in the squad car. You're going to get locked up. Maybe you won't go to jail massively, but you're going to at least spend the night in jail doing paperwork. Okay.
Yeah.
But if the owner of the 7-Eleven, or if the owner of the Highs, or pick your poison, Walmart, doesn't matter. Okay, bogart's $1,000 out of the paycheck of a worker who's much more vulnerable than the owner of a $500,000 franchise most of the time. That robbery or that theft, that abuse of trust, doesn't get the owner of the business thrown into the back of a squad car, having it, get fingerprinted. You don't see anybody on the show Cops throwing some business owner in Moncton or with waterfront property in Cecil County or Potomac in the back of a squad car.
Right. Yeah.
Even if they steal 100 times what would get you or me thrown in the back of a squad car for stealing out of a cash register or stealing out of inventory or stealing out of a Target, you name it. Now, Theft is wrong. Nobody should do it. But it's important to see that a lot of law and order people get real soft on law and order when it's the idea of taking the boss and treating the boss the way you treat a 19-year-old shoplifter for the same amount of money or 100 times the money. And so that's where I come in. It's not just a breach of contract. It's a breach of trust. Okay. And that's why the employment laws are so severe. That's why the Hebrew Bible is so severe on bosses who rip off workers. That's why the Christian scriptures in the letter of James are so severe. In the Islamic tradition, I'm told, I'm not a Muslim, that the instruction from the Prophet Muhammad, who is revered in that religion, is that the worker is to be paid before her sweat dries. And this is a religion that got started in the desert. So that's pretty fast.
Yeah, that is pretty fast.
That's not on Georgia Avenue in Silver Spring or in downtown Elkton, in the middle of July, sweating until you can't stop sweating. Your sweat dries in Saudi Arabia or in Egypt pretty fast, most of the country. And so that gives you the idea that it should be immediate. There should be no opportunity for breach of trust, yet it occurs. Shoplifting is bad and it's endemic and it hurts businesses, but there's more damage done from wage theft than from shoplifting. And that's why I feel lucky in that I get to feel good about what I do, for a living, representing workers. What I do is useful. It's important. It's anti-crime. Okay. So if you're law and order, I'm law and order, I'm law and order. I don't wear a badge, but I got a briefcase and 4 law licenses. So, I feel lucky to get to do what I do for a living.
Now, how does this process start? Let's say somebody thinks that they're getting shorted time, or maybe let's say, like, for example, a lot of times you end up, let's say you're getting paid bi-weekly.
Sure.
So you work a week, you work the next week, and it's the following week that you get paid for those 2 weeks.
Usually,
Let's say you get let go in that interim, and then that last check or that last direct deposit doesn't come. You worked a period of time, in that pay period, and your employer, for whatever reason, let's not even talk about this being a wrongful termination. Let's say you worked that whole first week and you walked into the office one day and you were fed up and you were like, hey buddy, boom, I'm out.
Sure.
So of course they let you go, and it's a valid reason to let you go. I'm assuming so. But they don't pay you for that first week you worked. What does the process look like? Obviously they call you or somebody like you and say, hey, Bruce, I think I'm getting shorted here for a week's worth of pay, or whatever it might be.
Sure. So here's the way would typically work. This is what Maryland rule is. Other states have different rules on this. In the District of Columbia, where I'm also licensed, the rule is more strict against employers. Employers have to pay the final paycheck a lot faster.
Okay.
In Maryland, the employer is allowed to pay the paycheck of the last paycheck at the regular next cycle. In other words, as if the firing didn't happen, they're not required to accelerate the final pay in Maryland. So it's a more moderate. I would say that Maryland, from my perspective, is a B+, A- jurisdiction.
Okay.
On this. So it's very good for workers. It's not perfect, but it's very good. I'm happy with the basic state of the law. But one relatively pro-management rule is that it's acceptable for management to pay workers who have quit or have been fired, let go, rift, whatever word, euphemism you want to use for it. No, not working there no more, no matter who or how, in the next regular pay cycle. So there's no legal need to cut a special payroll for a worker whose employment has ceased.
Okay.
But if that payment at the regular due date isn't paid, there are at least three laws that get violated. Okay, in almost every case. The first law is the minimum wage. And that may seem unusual because you might think, well, I'm being paid above minimum wage, right? Maryland has a higher minimum wage than the federal one. The current federal Maryland minimum wage for most workers, there are exceptions, is $15 an hour. In 2024, that's for work done in 2024, which is over twice the federal minimum wage. In Montgomery County, where my office is, it's slightly higher under a local law.
Okay.
And in the District of Columbia, it's even higher than in Montgomery County. And there are a couple of jurisdictions in the region, local jurisdictions, that are talking about bumping the number up now or later. It's too much to go into now. It's a big spreadsheet.
Right.
But it's important to keep the local law. So if you don't get paid that amount, even if you ordinarily get paid more than that, if you don't get paid that in your final paycheck, they've paid you zero. Zero is less than $15 an hour.
It sure is. Yeah. Last time, I don't have to pull out the calculator to do that math. Yes.
Yes. Now, for salaried workers, there are certain categories of classic salaried workers who are exempt from the minimum wage per hour as long as they get paid a salary of a certain amount. Currently, federally, at $684 a week. But if you get paid less than that, then that salary exemption disappears, and they violated the federal minimum wage as well because they've paid you zero, and zero is less than $7.25 an hour. So the federal minimum wage and the state minimum wage get violated if you don't pay the worker the last check.
Right.
And under the case law in federal courts, even a delay of just 1 or 2 weeks is enough to trigger the violation. If you remember the shutdown from around 2008, 2009, actually, I may misremember the year. It was a big government shutdown.
Yeah.
Back then. And federal workers who didn't get paid their checks immediately, just got their payroll slightly delayed, had a double damages remedy against the federal government for that relatively small delay in the pay. Even though they had a virtual assurance that the federal government would make it right, that didn't get the federal government off the hook for those workers. So prompt payment under the federal, under the overtime, as minimum wage laws and overtime laws, is an essential part of the jurisprudence. It's not defined in the statute exactly, but you're supposed to pay fast. End of story.
Right.
In addition to that, those laws, and we can get into the substance of those laws as well, there is what's called the Maryland Wage Payment and Collection Law. I often refer to it by the money section, the FIST section of the law, which is 3507.2. And 3507.2 of the Maryland Labor and Employment Law says that any wage that Maryland law requires, a minimum wage, an overtime wage, a promised wage, even a scale wage for certain types of state projects under the state financing laws scale wages for workers doing construction projects and the like for the government, local government, state government. Building schools is the most common one, or upgrading schools. Any wage that is unpaid and goes more than 14 days after the due date of the wage, so 2 weeks after the due date of the check, and for which there's no good faith excuse, no good faith explanation as to the reason not for paying, that can be subject to a triple damages remedy. You can demand 200% additional liquidated damages, so 3 times total, plus reasonable attorney's fees at an hourly rate on top. And to give you an idea of what courts have found reasonable, I've been practicing 29 years since my first law license, and I don't seem to have a problem getting courts to approve for me $4.25 an hour. Now, maybe that would be different if I were to, go into a court in a part of Maryland where rent is lower, everything else is cheaper, rent is cheaper, groceries are cheaper, lawyers are cheaper, doctors are cheaper, pizza's cheaper. Might be slightly less than that.
Where is that place? Because that sounds like a unicorn to me.
But understood. But there are parts of the state where the cost of living is a little lower. The economy is not as hot. I mean, rent in Somerset County is probably lower than it is in Montgomery County. For
right. Yeah.
States. But leaving aside that, in general, in federal court, lawyers who've had 20 years experience can generally expect to get an award of $300 to $475 an hour in wage cases, at least to be able to make a legitimate claim for them. The judge may disagree in a specific instance. And I say this, not because lawyers get so rich off of it. I mean, you're an attorney. We're the last mouths to get fed in any law office. First the landlord, the malpractice carrier, all the secretaries, paralegals, because we don't want to become wage defendants ourselves.
100%.
You don't want it. I'm a partner. I don't want to be named as a defendant. That's bad
right.
for my business. But that number, of course, represents the top line number that feeds every mouth, from the law book salesman to the landlord to the malpractice carrier to the heat and energy to keep the place cool and hot in the summer and winter, to paralegal staff, everything. And then at the bottom of the barrel, maybe the lawyer gets to eat. So, lawyers don't make as much as as people think we do.
No, and honestly, this isn't obviously a topic that we were looking to get into. What we do is very similar to trades. And a lot of people look at those prices sometimes. They're like, that's kind of ridiculous. You came out here to my house for 25 minutes, 35 minutes. Like, you're not paying for my time. I mean, we quantify, or at least you in these types of cases and other attorneys quantify their time. But
right.
What you're paying for is experience. You're paying for somebody's experience, their know-how, their ability to navigate these complicated systems. I mean, you're sitting here talking about somebody violating up to 3 different laws at the same time by doing, or more so not doing, just one thing.
Yes.
And, this isn't something that somebody's just going to pick up some textbook and look through and be like, oh, okay, I can handle this. I mean, it's quite a process. Now, with these cases setting up for you to be awarded attorney's fees as part of the remedy, is it fair to say that for the most part, people that are coming to you as a potential client are not paying you up front to handle these, and you're waiting until they're successful in the part of these to get paid?
Yes, in general, that is true. There are a couple of exceptions that I will get into for what's typical for how I practice. But in general, if someone has a wage claim under a wage and hour statute that provides for an hourly wage that's promised, an hourly wage that is a minimum wage, or an hourly wage that is an overtime wage, it could be all 3, depending on the facts. That is a case where we have a statute that provides us attorney's fees at the back end on top, and that is sufficient for us to take the case contingent, because I don't want to say we know we're going to win. The defendant could file bankruptcy. I've run into that a few times. I go into court, I've got a beautiful $60,000 case, and then I get a notice from the bankruptcy court saying, hi, your debtor is wiping your debt and another $500,000 that he owes to somebody else out. So that happens. It's frustrating. But in general, most wage and hour law firms, and there aren't that many of us, but most of us who do this work do not expect workers to pay much or anything to start a case, even a cost deposit. Most law firms will front that because we are able to get reasonable costs and reasonable attorney's fees awarded. for example, I'm a junior partner here, meaning I get all the pleasures. I get none of the pleasures of partnership and most of the challenges of it. But at my firm, my senior partner recently won a case where his client was owed approximately $200 in back wages.
Okay.
We thought the number was going to be higher initially, but it turns out that's what the worker was owed. But because of unfortunate decisions made by the defense, it took approximately 150 hours, if I remember correctly, of work to get it done. Billable work, everything from interviewing witnesses, depositions, attending mandatory court conferences, reviewing large piles of records, you name it, to where the federal court awarded $63,000 in legal fees and costs of around $9,000, most of it for deposition transcripts and I think one expert witness. And so that defendant owes $72,000 when that defendant owed our client approximately $200, as it turned out, in back wages. Now, that may seem outrageous, but the justification for that is that they don't want employers to be able to outspend the defense and keep workers from getting their just due, what the law mandates.
And you see people, you still to this day see people in all sorts of different areas of the law. At least we do, because we're in the mix. The people watching may not, or listening may not see this like we do. But I've heard stories, have seen firsthand examples of people fighting fights that I'm like, there is a clock that is ticking on the other end of this. You know, yes. You see this with two litigants in divorce cases. Sometimes, you know, you're arguing and spending time and arguing over who should own the iPad, where every minute or every 6 minutes the clock is running, and the clock is running on both sides. And I don't know if you've checked, but the value of that iPad is going down every 6 minutes. Sure. Because every 9 months it seems like they launch a new one, which makes the old one worth less. And, you know, a lot of times these things happen where somebody's piling up. You know, we've seen this happen. We've had a previous episode where we talked about medical billers who sometimes it's not even a bad bill. They're just bad at record keeping.
Right.
They've already gotten paid. Somebody didn't note it right. So now they're going after somebody, and then they fight. And then when they get awarded, or when our colleague and our client's side gets awarded all these attorney's fees, sometimes they end up being, like in a situation like this, substantially more, depending on how much the other side decided to put up the fight, than the claimant ever got in the first place, ever was hoping to get.
Sure. Well, what I'm about to say may sound strange. Probably won't sound strange to you, but may sound strange to some of your audience. One of the best things that can happen when I'm representing a worker with a good case is for a skilled defense attorney to enter the case, for a skilled, sophisticated employer.
Yeah.
You know, sometimes unsophisticated, well-meaning clients will say, you know, are you scared of a big company? Do big law firms scare you? And the answer is no. Because, you know, I once had a gun stuck at my head in the robbery, so I'm kind of hard to scare unless somebody brings a bigger gun than the one that was stuck at my head.
Yeah.
But the second reason is I welcome the entry of technically competent defense counsel into a case, because it will make it more efficient. It will make it far more likely that my client will get a remedy, because the defense attorney on the other side will be able to spot the issue. And if we're fighting, it's going to be a meritorious fight almost all the time on some bona fide legitimate dispute that's worth a fight, because the defense counsel is billing his own client or her own client, is aware of my bill, my fee petition at the end of the case if we prevail. And everybody acts like an adult in the room, ideally. And so these big legal fee awards happen either when defense counsel doesn't perceive the situation properly, or the client is being difficult and won't listen to good advice, or the rare cases when there is a bona fide dispute that just took that long to get resolved. Fight, a clock, fight about the clock, a fight about the calendar, a fight about some bona fide factual issue. And it's also true that judges do not always approve legal fee awards. I'm not going to name the law firm as I don't feel like getting a nasty letter, but there is a law firm of my acquaintance in Maryland that recently had its fee petition cut down by approximately 90%.
Wow.
And the judge in that case used some exceptionally strong language to criticize the fee petition, language that would probably lead me to offer resignation to my employer, maybe come in with a cardboard box to get my stuff, because I don't know if I'd have the nerve to show my face
Right.
around if I had a judge say something that harsh about me. Whether I earned it or not, I'm a proud man, and I would find that hard to bear. But it doesn't, judges do not automatically approve all these fee petitions. And again, the lawyers are not the most important part of this matter. The injured workers are.
Of course.
But your clients, your listeners have a right to have an understanding of how does this work practically? What are the lawyers actually doing to, how does the business model work? Is it like car accidents? And the answer is it's a little bit like how car accident practice works, but it's also a little different because of the peculiarities of the fee petitions.
But I mean, the important thing here is that somebody who thinks that they've been wronged, and maybe they're only wronged, $1,000, doesn't have to worry about, if they get into a difficult fight over this, being responsible for, you gave the example of a $60,000, legal bill or legal fee award that largely happened because the employer or their counsel or whoever it was being unnecessarily difficult. They end up making their own bed and having to lay in it, and not the aggrieved or injured worker that is out the money. They're just going to get made whole plus some with the treble damages, and not have to worry about, oh, well, it's all fine and good that I got this, but I owe my attorney more money than I recovered. Not
Correct.
the case.
Correct. And I mean, I can't promise that every such case works out that way, but that is the goal, and that is the typical practice when lawyers, and law firms that represent workers choose cases judiciously and don't run into nasty surprises during cases. That is the typical model, the desired model, so that the worker is not, who's not, doesn't have a paycheck, maybe facing eviction. I mean, here's an example. I represented a worker last fall, well, all year really, but it got intense last fall, into fall of 2023, against a restaurant in Prince George's County that was violating the wage and hour laws. For reasons known perhaps to Providence or God, but not to Godfrey, this defendant did not respond to a bombardment of notices to contact us, to contact the court. We sought what is known as alternative service. You know what that's about, where we got special permission to serve a defendant by alternative means because we had evidence to believe the defendant was willfully or deliberately or indifferently disregarding notices in the traditional service of process way. So we got permission to get service by first-class mail notices to a stack of addresses where this gentleman might have been. And we wound up getting a judgment for about $50,000. The problem is that that's a white paper judgment, right? That's, now we get most of our notices electronically, but they're printed on PDF that's white, or white paper when it comes out. And that is not something that your landlord will accept, or the Giant will accept, or 7-Eleven will accept. They want green paper, or a debit card or an Apple Pay drawn on, U.S. green money. And towards the end of this case, my client was a restaurant worker. He had been ripped off out of his pay. He was living in a box truck, which is bad in September, and it's worse in early December because it gets cold. I mean, I would welcome it getting cold, but I also have heat in my home. You know what I mean? So, I don't freeze at night in my home. I turn the heat on and I'm fine. This guy was living in a box truck, starving half the time. I was trying to get him connected with Catholic Social Services or something to get him some food in his belly, get him a place to stay. Finally, we got the sheriff to run in and seize the liquor license off the wall. And when that happened, somehow the owner, who'd been ignoring me for over a year, managed to put a $50,000 certified check in my hand within 3 hours.
Imagine that.
I can't even imagine how fast this guy had to be driving. Like, it was probably a menace on the Beltway, to get from his restaurant to my place that fast. I mean, how can you do that? There's traffic in metropolitan Washington. And, we put that into escrow as soon as it cleared almost instantly with the cashier's check. And we were able to put, after our fees and costs, which were significant, a large 5-figure check into a guy who had no home. He could buy his food, get a place to stay, get a shower. It was, I would say, one of the top 5 experiences of my life as a lawyer. It's not a case that will ever get written up in the legal newspapers, but at the end of my days, it's going to be one of the cases that I will remember. Our memories fade.
I mean, it's making a significant impact on somebody's life, especially at a time that's probably one of the worst times in their life. To be able to help turn that around is huge. So we are definitely into overtime here. I want to thank you for sharing your time with us. It's super valuable. I know that this episode is going to result in a lot of questions. So feel free, if you have those questions, to the normal ways, hit up info@bowerslawmd.com. Feel free to call my office. We'll get you in touch with Bruce. If there's anything that you think that we've talked about today that applies to you, don't delay. Let's get that going so that we can get you taken care of and you're not living in a box truck. And if I get a bunch of questions on this topic, we can take it, because there's so much more to unpack than what we were able to talk about today. We will absolutely have you on for another episode in the future, because there's just a ton to unpack in this whole thing. So,
well, I can't thank you enough for the opportunity, Jobeth. It's a pleasure to finally meet you face to face, even through a screen. And I appreciate the opportunity to participate. I'm proud of what I do. I'm glad to talk about it, and thank you.
Yeah. So again, if anybody has any sort of needs, if they think that they're getting this, feel free to reach out to my office. We will connect you as quickly as possible with Bruce. And as always, until next time, be well out there, be safe, and we will see you next week.